All righty, folks. Hello? Hello? Everyone? Thank you. I hereby call the Police Oversight Commission meeting to order on Thursday, June 11, 2026 at 5:04 p.m. Madam Secretary, please conduct the roll call.
Commissioner Goronsky, Commissioner Mejia,
Present.
Commissioner Perea,
Here.
Commissioner Said, Commissioner Vega,
Here.
Vice Chair Castillo-Lawton,
Here.
Chair Carpenter.
Here.
Record shows we have 7 members present. Chair, you have a quorum.
Thank you. Now it's time for the Pledge of Allegiance. If we'd all stand for the Pledge of Allegiance, I'd appreciate that. Thank you. All righty, now it's time for public comment. Next, we have the public comment section. This is the time for commission to receive comments from the public. We will not accept any additional requests for speaker cards once we begin the public comment sessions. If you have not already, please submit your request to the recording secretary. Speakers will have 3 minutes to speak. Madam Secretary, do we have any public speakers?
There are no in-person speakers at this time. We do have one individual on Zoom. Manuel, if you'd like to speak, please raise your hand. No. So at this time, there are no speakers. Chair.
Thank you. All right, next is the consent calendar, items number 1 and 2. Is there a motion to approve the consent calendar? Microphone, please.
Pardon me? I put it on. I move to approve it. I second.
Do we have a second?
I just did. I second.
I'm sorry, I couldn't hear you.
It's on. I second.
So I have a motion by Commissioner Goronsky, seconded by Commissioner Mejia, and that was to approve consent calendar items 1 and 2. Commissioner Goronsky?
Yes.
Commissioner Mejia?
Yes.
Commissioner Perea?
Yes.
Commissioner Said?
Yes, thank you.
Commissioner Vega?
Yes.
Vice Chair Castillo-Lawton?
Yes.
Chair Carpenter?
Yes,
The vote is 7 ayes, 0 nay. Motion carries.
thank you. All righty, that's the end of the consent calendar. We will now recess this portion of the meeting to consider items number 3 listed on the business calendar at 5:07 p.m.
Oh, God, that scares me. Scare the heck out of me. There's no water in there. Take it in there, do they?
All righty then. We are back. I hereby reconvene the Police Oversight Commission meeting to order at 6:40 p.m. Assistant City Attorney, do you have anything to report out of closed session? Thank you. All righty. That ends, okay, now we're on the business calendar and we're going to start our study session, which is item number 4 relating to Know Your Rights, interacting with police. May we have a staff presentation?
So Commissioners, this evening we have a presentation from Amaris Montes and Ali Rubenfield with the ACLU regarding the rights and responsibilities of members of the public when interacting with the police. Both are attorneys with ACLU's Criminal Justice and Police Practices Project based in Los Angeles, and I've made the long drive from LA to speak with us here in Santa Ana. So welcome. Thank you so much.
How's that? Thank you so much for having us. Again, my name is Amaris Montes. I use she, her pronouns, and I'm joined by my colleague, Ali Rubenfeld from the ACLU of Southern California. We're both staff attorneys there. And so today we're just gonna go over a little bit of, know your rights information about different situations and interacting with the police. And so, we'll provide just kind of general information, but obviously this isn't meant to be any sort of legal advice for anyone who, might watch this in the future, any community members who might use this resource in the future. Obviously, all of these situations are really fact specific. And so if anyone has questions or has specific needs, then they should really reach out to an attorney. And also note that this information, like the law on this, is always changing. It's really fact specific, and so it's really important to get kind of re-up this information every year or so, because the law is always changing on this. There's new decisions at the federal level and the California level, so it's just important to use those resources that are on the ACLU's website, along with a lot of other nonprofit organizations that provide really good know your rights information. And I wanted to go through the agenda and just wanted to see how to go through the slides. Oh, perfect. Oh, there we go. So just to give a little bit of overview of what we'll go over today, we'll do a little bit introduction of both of us and a little bit of background of who we are, give some general information about the specific rights, like where do these rights come from, what laws govern here, and then go into different contexts of what are your rights in interacting with police in different situations. So for example, in the home, during traffic stops, if you're a pedestrian on the street, once you're under arrest, during protests, and then we'll talk and end a little bit about the interaction between police and ICE, and that kind of cooperative dynamic or not. And so just to give you a little bit of background about me, I just joined the ACLU, but before this, I worked for about 4 or 5 years for another national organization called Rights Behind Bars that does civil litigation on behalf of people who are incarcerated in different jails and prisons all across the country. So really doing litigation for civil rights violations for folks who were incarcerated in those settings. And I'm also an instructor at UCLA School of Law, where I help to run their prisoners' rights clinic. And I'll let Ali introduce herself as well.
Good evening. Thank you for having us. My name is Ali Rubenfeld. My pronouns are she, her. I also just started as a staff attorney with the ACLU SoCal. Prior to that, I was an attorney and I worked at the Loyola Anti-Racism Center at Loyola Marymount University in partnership with Over Police communities throughout Los Angeles. A lot of that work centered around oversight and around making sure that it could be the strongest mechanism possible for accountability. So I'm very grateful to be here tonight and be in conversation with you all.
So yeah, I'll do the first half of the presentation, then Ali will take over for the second half. So just starting off, we want to, really reiterate that safety is the overall priority in these interactions with police. I know things are like constantly moving. It's really, these situations are hard to figure out what is the best practice of what to do, and we'll, obviously these rights govern, but also want to urge people to, tap into their instincts and what is going to keep you safe in that moment and make sure that you are as safe as possible and the people around you are as safe as possible. And it's really the responsibility of police officers to de-escalate the situation. That's part of their job. And so that responsibility really lies with them. And so just providing a little bit of strategies for just making sure that that risk is reduced for yourself and others. We provide some just tips here for the public. And generally that's, not to get in an argument with a police officer, not to resist arrest, not providing, like false documents, not running, keeping your hands where you can see them, things like that. All of that is really important to make sure that you're as safe as you can in those situations. And, there might be violations that happen. And so we urge folks to really just the method there is to think about and make sure that you're accounting for what is happening to be able to document that in the future, to report the violations after the fact, but not really to resist arrest in that specific interaction. And so when we talk about these rights in these interactions with the police, what rights really govern here? And so the answer to that is the Fourth and Fifth Amendment. So we'll start with the Fourth Amendment here. And you'll see the text of the actual Fourth Amendment on the left, but it's a lot of words. And so what does it really mean? And so the Fourth Amendment really just protects people from being searched and stopped and having their things taken away without reason, without reasonable suspicion and probable cause, which we'll talk about what that means. So that means that they can't just search you whenever they want. There's some situations that unless they have probable cause or reasonable suspicion, that there are some, exceptions to that requirement. So in exigent circumstances, or if someone gives them consent. And so we'll talk about those also specific categories of what are those exceptions and what happens when people consent. So just touching on these different standards under the Fourth Amendment. So I talked about police can, stop you and search you if they have probable cause. They can stop you if they have reasonable suspicion, but then their search of you has to be more limited. And so what do those ideas mean? But first, starting off, the kind of default is that the police are required to have a warrant to search you, search your home, to search a business. And so a warrant is really just a legal document that is signed by a judge where it details that the officer, the police have probable cause in that situation that a crime has occurred. And again, we'll talk about that in a second, but, and it has to really describe everything that, with particularity of the location to be searched and the things to be seized. So, even if they get a warrant for your home, they can't just like search and take everything in the home. They have to really, it has to be connected to whatever crime they are investigating, for example. And so it has to be quite detailed in the warrant.
If I may, a quick question. Can you explain a constitutionally protected area?
Sure. So a constitutionally protected area is what is considered to be kind of your privacy space. And so there's a lot of, different case law that defines that, but we'll talk about in a second, in the situation of your home, that is the most constitutionally protected space, right? Now, if you go outside of the inside of your home or specific places that are seen to be especially private, for example, like your garage or an ADU unit or something like that, that is thought to be like that is still an integral part of, your private space, then that's where your expectation of privacy is lessened and that a police officer could have more of an ability to search you. And so things like, public sidewalks or, even situations where your trash is put on a public street instead of next to your house, then they can search your trash in that situation. So it's really tied to this idea of like what is a private space and considered to be a private space, and kind of how we think of society. And so that's also why an officer can, who has reasonable suspicion, can stop you on the street and do more of a Terry stop, a pat down or something, because those areas are less protected than maybe your business or your home. But thank you for previewing that. And yeah, there are some exceptions to the warrant requirement that again we'll touch on. So in in an emergency situation, if someone could be at risk of serious harm, like someone screaming in the home or something like that, then a police officer might be able to enter. If there is consent from people who live in the home, or in your car or something, then the police would be able to search in that situation. A search incident to arrest, also the police can do more of a search in that situation, or if something is just like in plain view. So if they enter to your home or in your car and just see something that is illegal, then that is kind of an exception to the warrant requirement. And so again, police are required to have probable cause, and what that means is really facts and circumstances that would lead a reasonable person to believe that a crime has been committed. And so it has to be, that there has to be evidence that you committed a certain crime. It has to be quite specific. Reasonable suspicion, on the other end, is a lower standard to meet. And so it's just articulable facts that someone may have engaged in criminal activity or is about to engage in criminal activity. Is described as more of a hunch. And again, that's a less demanding standard, but that means that police officers can only stop you briefly and do what's called a Terry stop, a pat down search of you. And so again, your rights in the home are the most protected space, police officers cannot go in and search your home without a warrant. Again, those exigent circumstances apply here. So if there's imminent threat to life, or if there's, an officer is following someone, a suspect on foot, and needs to enter your home, then they're able to enter, that's kind of an exception to the warrant requirement. The police are also required to knock and announce their presence unless doing so could put them at risk, or others at risk, or if it would cause destruction of evidence in some way. And so if they think that, for example, someone has, a firearm in the home, that they would use it if a police officer would knock on the door, then they're not required to knock and announce. And so, of course, an owner or resident of a home can consent to a search, and that is one exception to the warrant requirement as well. And anyone who is a resident in the home has that ability to consent and would have the power to do that. But if any one of them doesn't consent, then police officers are not required or not allowed to enter and search a home. But there's been cases that, like, if the person who doesn't consent then leaves, and then the police officer comes back when they're not gone, then the person who didn't consent, that consent wouldn't apply anymore because they're not in the home anymore. But also consent can be revoked. And so if someone initially consented and then no longer wishes to have the search continue, then at that point any further search would be illegal or unconstitutional unless they went and got the warrant, or unless something that they found caused probable cause for them to think that a crime has been committed, or that they could tie the person to that crime. Oh, sorry, and just going back to this, it's not on the slide, but also this applies to businesses. So in private areas and businesses, police officers are not able to search those private areas. So usually, that's like marked by employees only, or something like that. But it's places that are, public, so a dining area or a lobby or things like that, officers can enter into those, public spaces. So what are your rights during traffic stops? So, and just speaking a little bit about, the rights of both drivers and passengers in this situation. Both drivers and passengers have the right to remain silent. Passengers especially can ask if they're free to leave, and if the answer is yes, then they can, silently leave. Drivers are required, obviously, to provide their driver's license if asked. And if not, then, there's risk of getting ticketed or to get another offense. And both drivers and passengers do not have to agree to a search of themselves or their vehicles or their belongings. And so, they can audibly say, I do not consent to a search. Police can no longer ask, to tell them why they stopped you, that classic, like, police, do you know why I stopped you, kind of question. They're not allowed to ask that anymore. People can instead ask the officer, why was I stopped? And that's like the appropriate kind of step there. And police are allowed to order both the drivers and passengers out of a car during a stop. So, the best way to reduce risk is to stop the car in a safe place as quickly as possible, turn off the car, open the window, and place, your hands in, just where the officer can see them, and showing, again, the officer your driver's license if asked. And just like being cognizant of your body, not making sudden movements. So, that's the best way to make sure that everyone is safe in that situation. Sure.
Do the police have to provide the reason for the stop?
Yes, that's the change in the new law. So, yeah, again, they can't ask you, do you know why? And when you ask them, they have to tell you the reason why they stopped you. Sure.
I'm sorry, a quick question. Are you required to turn off the vehicle?
Yes,
I-
that's a good question. I mean, you're required to stop the vehicle, and I think if if the police officer asks you to turn off the vehicle, then you're required to turn it off.
But does turning off the vehicle imply consent to a search?
No, that does not. Yeah.
Okay, because I've heard otherwise.
Oh, really?
Yes, ma'am.
Okay, I can check that.
Yeah, if you would, please. Thank you.
Yeah, well, especially because, I mean, in that situation, I mean, I guess it would depend on whether there was probable cause or reasonable, if they're just being stopped for a regular traffic violation, then, there's not an ability to search the car at that point. They're required to show the driver's license and everything like that. But at that point, if they just have the car on, it doesn't seem like there would be probable cause to assume that they could search the car in that situation. And I don't think that it would be considered consent. There's no like audible thing that was said, but yeah, happy to research that and get back to you.
Another question on that. Are you supposed to lock the doors when you exit the vehicle? Does that, if non-locking the doors imply search or no?
If not locking the doors.
Yes, ma'am. You exit the vehicle as ordered, and you do not lock the door. Is that an implied search or no? Or implied consent, my apologies.
Implied consent. I wouldn't understand that to be consent either. Yeah.
Okay.
Yeah.
Consent needs to be pretty explicit in that scenario. The officer would say, can I search your vehicle? Or if you got out and walked away and said, sure, but there's merely unlocking your doors or walking away from your vehicle with your doors unlocked would not be consent.
Okay, so just to be clear, then you have to actually explicitly say, I give consent. Is that correct? I'm sorry?
Yes, it has to be explicit. Yes.
Thank you.
Sure.
So in the context of an officer providing the reason for the stop, So they have to provide the reason, you said. If they don't, is that a constitutional violation? Or like, where does that requirement come
I
from?
think that requirement is a statute. It's a California
Okay,
statute.
so it's a California-specific law.
Right, yes. So it's not a constitutional, and there are places in the country where that doesn't apply. So, yeah.
Does this state when they're supposed to tell you that? Do they have to tell you that before they ask for an ID? Or,
I don't think that it has a timing requirement
because
about
most people
it.
tend to right away ask, why am I being stopped? And then the officer's asking for an ID, and then there's this like conflict that happens sometimes.
Yeah.
So I'm wondering if the officer, once asked, if the officer needs to give the reason why they were stopped.
The driver would have to turn over the driver's license regardless, so the order doesn't matter as much as the officer does have to explain why they're pulling you over.
What's the statute that just passed?
I don't have that number on me, yeah. We can give it to you after this, though.
Sure.
Yeah, it's pretty easily found, yeah.
And sorry, just one follow-up question. So does the same rule apply to an arrest? So suppose an officer stops you and they stop you for some like pretextual reason. And then they find out that you have like,
Right.
I don't know, some drugs in your car or something like that, and they arrest you, and you ask, why are you arresting me? Do they have to tell you why they're arresting you?
In that situation, yes, yeah. And obviously that situation happens all the time where it's just a normal traffic violation, and then they find something that causes them to have probable cause for a crime. And in that situation, they're required to tell you you're under arrest for a certain crime, and then give you all of your Miranda warnings, which we'll talk about soon. And so, yeah.
Is that a constitutional protection, or is that again under the state law?
No, it's under the Constitution.
And just real quick, to Commissioner Saeed's question, is California Vehicle Code 2806.5, which I think this is what you're referencing.
Yes.
It states a police officer making a traffic or ped stop before engaging in questioning related to a criminal investigation or traffic violation shall state the reason for the stop.
So does that only apply to vehicle stops?
Traffic or ped stop, pedestrian stop.
Pedestrians also, yeah. Other questions? Great. So again, if you're pulled over by the police, they might have reasonable suspicion that based off of a traffic violation, but that doesn't mean that they can search your car. And so they still have to meet the basic requirements of what is required for a search. So again, the warrant requirement applies to a car. But again, there are various exceptions to the warrant requirement for a search of a car as well. And so things like, again, plain view. So if they see something, drug paraphernalia or something like that, it's just like sitting on your dashboard or something, then that would be an exception. And then the police can search your car in that situation. A search incident to arrest. So if police can search in your vehicle to look for weapons or evidence of the crime that you're being arrested for. And then again, consent. So the person, the driver, can provide consent in that situation. Importantly, the passenger can't provide consent, but if the driver does, then they can conduct a search at that point. So now touching a little bit on your rights as pedestrians. So again, you generally don't have to show your ID to the police officers unless you are detained or arrested. And so an officer can briefly stop and frisk you, again, touching on the Terry stop, based off of reasonable suspicion. So they can touch your outer layers of clothes to see if there's weapons or if there's evidence of a crime that they have reasonable suspicion for. And so in that situation, that would be considered like you're being detained, and you would have to provide your ID at that point. But before that, if it's just the police officer has no reasonable suspicion, then you're not required to provide an ID. Police officers, again, are required to tell you why you're being stopped. And different rules apply to people on probation or parole. So the law permits police to generally search people who are on probation or parole.
I have a question on this one. Hi.
Sure, yeah.
So I think, sorry, this is really loud. I think this is one of the issues, right, that kind of arises a lot in oversights of like stop and search, whether the search was lawful or not. Can you, because my understanding here, based on what you're giving us, is that an officer has the right to briefly, right, just ensure that there's no weapon used, but is there a, like, how do you define what is too much
What is too much?
of the brief, like, frisk?
Yeah, usually it's just they can pat down your clothing and provide, and it has to, be an obvious thing like that a gun is in your pocket or something like that, or
But if
that-
there's nothing, let's say there's nothing, maybe you have a purse or something, do they have the right to, like?
they can't go into your purse. So it's just, your outer layers of your clothes.
If your purse is open?
No, not that either. So, well, that would be maybe a plain view exception to that. So if it was open and there was like something obviously illegal, then maybe that would be an exception there. But if your purse was just open and there was nothing obviously illegal there, then they can't say, hey, your purse is open. I can just
They
go
can't
search
say,
it.
I was afraid that there was a gun there, so therefore I searched.
No, yeah. Well, it's anything, I guess it depends on where the purse was. If it was like an open purse that was in your hand and you can grab it in that situation, then yes. If it was like on the floor, not very close to where the person is, then they wouldn't be able to search it. So it kind of depends on if it's like within your control or area. But if it's, so it depends on where it is. But if there is no gun, then, and that's not obvious, then they can't, like go through your pockets more or anything like that. It has to be like very obviously to the touch a weapon or like evidence of the crime that they're thinking that you're engaged in.
They can't like pull your clothes or something, right?
No.
Okay, thank you.
Quick question on the other slide too. It says police officers are usually required to tell you the reason they've stopped an individual before asking you questions. Where does that come from?
It's the same statute.
Okay.
Yeah.
For
Because it
the
applies.
pedestrians, okay.
Yeah, it applies to both pedestrians and traffic stops. Okay, great. So touching a little bit on cell phones, I know this is a really important topic. People have really important information on their cell phones. And so the police generally can't search a cell phone again without a warrant. If a police officer requests to look at your phone and you give it over, then that is considered a consent to a search. And so to protect yourself from an unlawful surveillance, then it's important to have the cell phone to be password protected. So all of your devices, smartphones, computers, tablets, and then with biometric unlock, because you can just hold it up to your face or have your fingerprint on it, then it's most protective to not have those things in place and to have more of a password protected thing, because in those situations it has happened where they just hold it up to your face or force your fingerprint and can then enter into your phone. And then just generally it's important to evaluate the privacy and location settings to be the most protective for cell phones. But generally, again, police officers are required to have a warrant to search.
I have a question for you on this. In the beginning, you said comply, correct, in general?
Sorry?
In the beginning of the presentation, you said comply in general with requests, right? So I say, no, I'm not giving my cell phone. Now what?
Then if you say that you're not giving the cell phone, then you're
Correct.
not consenting to the search, right?
Correct, but is that considered An aggressive action, is that considered non-compliance?
No, your non-consent to a search does not give an officer reasonable suspicion or probable cause because it's just a constitutional right to not have to do that. So it doesn't provide any more reason for the police. Under the law, it doesn't give them any more reasonable suspicion or probable cause.
Yeah, I'm not speaking about probable cause or anything like that. I'm just saying from a compliance aspect, is that going to be viewed as being non-compliant or aggressive or something along those lines? Because again, in the beginning of the presentation, it says clearly, comply.
Right.
You see what I'm saying?
Well,
Let me see your phone. No.
Yeah, police officers should know the rights that people have to refuse to consent to a search as well. And so hopefully they understand that and know that it's not an aggressive search because, or an aggressive act because they should be informed of people's rights under the law.
And if they have a probable cause, they should tell the person, I need to look at your phone for.
Because you're under arrest.
You're under arrest.
Right.
Because one incident that I'm thinking about is somebody that's in a store, a male is accused of recording females. Officer shows up. Does he have the probable cause to ask that person, I need to look at your phone?
Yeah, like inappropriately record.
Inappropriate pictures, yeah.
Yeah, then, I mean, it would depend on the situation and the particular circumstances there, so I can't say whether he would have probable cause or anything like that, but it could lead an officer to think that he's doing.
But there are situations where they have that, the officer has the right to look at their phone.
Yes, so in like some of these exceptions, so if something was like very obviously, again, so because that was in plain view that it was on the phone, that something illegal was happening, like if he saw him taking the pictures or something, then that's an exception that would then lead them to have the ability to search the phone. Yeah, that might go under an exception, but generally they would need a warrant to search.
If I may, slide 4, even if you object to a search, never physically resist or pull away.
Right.
Go for the phone, you pull away. You see what I'm saying? I mean, how these things can get kind of tricky.
Right, and that's a safety tip, but that it's still, again, is a requirement under the law that they should be respecting people's refusal to consent to a search.
Can I ask one more question? Because I think this is what you're getting at, and I think it is important, so I do appreciate you bringing this up, and I appreciate like your first slide that kind of reflects that the responsibility lies on the trained officer, right? And not the individual. And so I think what Keith might be getting at, and correct me if I'm wrong, is that a lot of times, at least for us, right, as commissioners, we get complaints. And then sometimes, as we're assessing and deciphering the facts, if people are not complying, sometimes some people might interpret that as if the individual fails to comply, then the officer had the right to use X amount of force, which is not true. So I think he's asked, that's kind of what you're getting at.
Yeah.
In a way, yeah, it's.
In a different question, but yes, and I think that's really good to clear up because there have been times here where people have said those kind of things which are incorrect, so it'd be helpful to hear from a
Yeah,
attorney.
it seems like it's a fine line, right? Where you're trying to be compliant, but it can be construed as being non-compliant.
I just want to briefly interject because I think I'm hearing some dialogue about conversations had in closed session. So I would just caution the commissioners that we can't talk or disclose, even I think it's not really a hypothetical sense, even if it's not tied to directly to a case. If we're talking about discussions had in closed sessions, those are confidential.
But I understand, kind of the tension that you all are discussing, and but especially in a situation where someone just verbally says, "I don't want to give my phone. No, I don't want to give it to you." Then, hopefully as you mentioned, hopefully the police officer has been trained on what is required under the law, is able to de-escalate the situation, and can follow just the basic right for them to not consent to that search.
Just to follow up on that, so I think there's some overlap. If an officer is investigating someone and the second slide you had talked about safety of yourself and how to comply, which I thought was an excellent slide. If the person isn't answering questions, but there is reasonable suspicion or there is probable cause for an arrest and they're not answering, wouldn't that give rise to a 148 potentially if they're not complying with requests? Not about a cell phone search, but just, can I see your ID? Can I,
Yeah, right. So again, if someone has, if the officer has reasonable suspicion or probable cause, the person is required to give an ID. If someone is under arrest and there's probable cause for a crime, then under Miranda rights, then they have the right to remain silent. And so, hopefully the officer understands that their failure to say anything might be them imposing their Miranda rights in that moment. So, obviously we want to stress the safety of everyone involved is the most important thing, but it's also important to respect these very specific rights of folks in those situations.
Thank you.
So again, we really urge people to be clear about stating that they, both questioning whether they're being detained or not, to understand, especially in the situation where you're asking, do I need to give this driver's license or not? Am I being detained? Because that will really clearly tell you whether you need to do that or not, or whether you're free to leave. And clearly stating as well that you don't consent to a search. And saying so very explicitly, very clearly to the police officer, because I think that also reduces some of the risk there of, just saying no or something, but saying, I know that I have the right to not consent to the search. That's what I am, I'm exercising this right in this moment. And then if people are then put under arrest, very clearly also saying, I'm exercising my right to remain silent. I want to talk to an attorney. Sometimes those things can be misconstrued. If you just say, oh, maybe I don't want to talk right now, that's might not be enough to really exercise and convey to the police officer that you're exercising your right to remain silent. And so we really urge the public to be clear about them exercising those rights for the safety of everyone. Oh, sorry.
So the second bucket of constitutional rights that come up during police interactions fall under the Fifth Amendment. And the Fifth Amendment is where the guarantee to due process comes from. And that basically means that individuals have a right against self-incrimination and against coercive police practices. This is also where the Miranda rights come from, which is we have all heard these 100 times on cop shows. You have the right to remain silent. Anything you can say will and can be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights? Have you read them? And they have to be in a language that you can understand. When it comes to the right to remain silent, that also means that you don't have to answer any questions about where you're going, where you're traveling from, what you're doing, where you live. And if you wish to exercise that right, we do recommend that you say it explicitly out loud to avoid any kind of confusion around whether you're resisting or you are exercising your constitutional rights.
I have a quick question.
Yeah.
Do the police have to read you Miranda rights when they arrest you,
Yes.
even if they don't question you?
It's as soon as they arrest you, you have to be read your Miranda rights.
Is that under state law or is that a constitutional?
That's constitutional. Yeah, it's Miranda v. Arizona. It's a Supreme Court case.
So they have to read your Miranda rights even if there's no in custodial interrogation?
Right. As soon as they put handcuffs on you, they have to read your Miranda rights. Any other questions? Okay. So as far as general rights after arrest, again, for folks' safety, we say do not resist arrest even if you believe the arrest is unfair or unlawful. There are ways to address an illegal arrest after the fact, but just for your safety and to make sure everybody comes home, we always advise folks to prioritize their physical safety when interacting with law enforcement. The right to attorney means that if you can't afford one, it will be provided for you. That also means that you are not required to say anything, sign anything, or make any decisions without a lawyer. And as far as during the course of an arrest, you can be searched. It's called a search incident to arrest. However, that is limited to what's described as the wingspan of the person. So that goes back to what Amaris was saying about they can search your person, but they can also search the area surrounding you in case. And the theory behind that is to ensure that the officer is safe and to potentially secure any evidence that could be destroyed just within the person's wingspan. As far as in vehicles, an officer can also pat down a passenger in a vehicle or other residents in a home if the officer reasonably suspects that those persons could be armed and dangerous. And if an individual, in any of these scenarios, if a person believes that their right has been violated, once they're safe, we advise that they write down everything that they remember. So that includes an officer's badge number, any patrol car numbers, the agency that they belong to, and any other details, and if there were witnesses to the event or folks who filmed it, getting their information as well.
The phone call is at the jail or on the spot where they're being arrested?
It'll be wherever they're brought to.
Oh.
So it's either in the station or the jail.
Got it.
So the First Amendment protects our right of free speech, which forms the foundational basis of our right to protest. And this can come into tension because a lot of times when folks protest, they are forced into situations where they're interacting with law enforcement. However, and the First Amendment protects our right to express our opinions, and even if they're unpopular, and that means that folks can criticize the government, they can criticize the president, they can criticize any kind of official. However, there are limits that are placed on this speech. The right does not extend to libel, slander, obscenity, true threats, or speech that incites imminent violence or illegal activity. However, you can't be held responsible should the people in attendance with you commit unlawful acts as long as your words don't directly incite that violence or lawbreaking, and you are not liable for the way that counter demonstrators react to your messaging. In general, for protests, you ordinarily do not need permits to march on sidewalks. However, if you're obstructing cars or pedestrian traffic, that can change. Police can ask protesters to move to the side of a street or a sidewalk to ensure that other folks can pass for safety reasons. And certain types of events may require permits, and the procedures vary by city or county. So we recommend that folks look at their local ordinances to understand what they have to do in order to safely protest.
Can I go back to the Miranda issue?
Sure.
For the Miranda, I've always learned it to be read to a suspect or a person who's being arrested if an interrogation is about to start.
It's just in general if you're arrested. It's to notify you that even before an interrogation is going to happen, you have these certain rights. Sometimes they'll detain someone and take them to the station before they've formally arrested them, but as soon as you've been arrested, which is a different process than being detained, then they have to read your Miranda rights. So that can happen out on the street, or that can happen in the station.
So if you're placed in cuffs, this is my understanding reading case law regarding the Fourth Amendment. If you're placed in cuffs and you're just put in the car and no one's spoken to you and you're making comments as a person who's arrested, the officer, and the door shut, they don't hear you. The officer doesn't have to read the Miranda rights at that point. But let's say you're driving to the police station and they start confessing, the officer would then be triggered to read the Miranda rights.
The best practice doesn't hinge on when you start speaking, it hinges on the arrest itself. So the best practice is that law enforcement is supposed to read the Miranda rights as soon as they've arrested you.
And that best practice is separate from what the legal requirement is.
No, there's the legal requirement, but with all this law, like we're kind of sensing today, there's a lot of case law about this. It's a really complicated area and it's really fact dependent. However, law enforcement, when they arrest someone, they're supposed to read them their Miranda rights. That is so that folks know that they do not have to speak. The whole idea is to prevent someone from self-incrimination and making sure that they know that they have no obligation to continue a conversation with a police officer.
I would just chime in and also just echo what Commissioner Syed has said, which is that I have also, in learning the Miranda doctrine, understood it to be that you only need to be Mirandized prior to and in custodial interrogation. And so theoretically, the police could arrest you and they never interrogate you, ever. They don't ask you any questions, and they don't read you your Miranda rights. There's no violation. At least that's my understanding.
Same.
Agree to disagree. Yeah, I mean, my understanding is that the best practice is that they do it right when they arrest you to prevent you accidentally speaking when you're not supposed to, and then that wouldn't be admissible in court, right? So the whole idea is to make sure that whatever the person being arrested says, if they say something useful, can be used in court, and that they're aware that whatever they say can end up there. Okay, any other questions around that? Great. So police are permitted to break up protests through dispersal orders. However, they may not break up a protest unless there's a clear and present danger of a riot, disorder, interference with traffic, or an immediate threat to public safety, or the protesters themselves are engaged in unlawful activity. If the police do issue a dispersal order, they must provide a reasonable opportunity to comply, meaning sufficient time and a clear, unobstructed exit path. And the police must provide notice of the dispersal order before anyone can be arrested or charged. So that means that they need to provide notice of how much time individuals have to disperse, the consequences of failing to disperse, and the clear exit route people can take to safely leave the area. For community members who want to be as safe as possible, we make the following recommendations about attending protests. Arrange for legal support in advance and invite legal observers to attend, make arrangement for legal representation if needed, carry that number of an attorney as an emergency contact for yourself, wear clothing that you can easily move in, and consider wearing protective eyewear, and protect yourself from surveillance. It's similar to the cell phone advice. Password protect your devices, make sure you don't use the facial recognition software, evaluate your privacy and location tracking settings, and consider the potential harms of posting the identities of the bystanders.
Excuse me, I have a question for you. And the police may not break up a protest unless there's a clear and present danger of riot, disorder, interference with traffic, or other immediate threat to public safety, or the protesters are engaged in some form of unlawful activity. That one person, 10 people, 5 people? Because it seems to be kind of unclear when that definition kicks in.
Right. Again, I mean, it's a squishy area. In general, and we'll talk a little bit more about this with AB 48, but police are, if there's one person in a crowd acting out, they're not supposed to order a dispersal order. It really is a public safety minded order, so it's about like the control of the crowd itself. So AB 48. AB 48 has to do with law enforcement's use of less lethal force. So this law was enacted following the summer of 2020 with the George Floyd protest. California legislators enacted the state law, which limits the use of militarized equipment for crowd control. It was enacted in 2021, and the state law prohibits use of chemical agents and impact projectiles for crowd control, except in extreme situations defined in the law, and only after law enforcement has taken several steps to address the situation about these militarized weapons. AB 48 restricts the use of tear gas, pepper spray, rubber bullets, and other less lethal weapons for crowd control, except if the use is objectively reasonable to defend against a threat to life or serious bodily injury, or to bring an objectively dangerous and unlawful situation safely and effectively under control. These are narrowly defined situations, and law enforcement may only legally use these weapons after they've reasonably tried to de-escalate. And those attempts have failed. They've announced the intent to use less lethal weapons, and they do so in the appropriate language. They allow an opportunity for individuals to leave the scene, and they only target folks involved in the violent acts. So that goes back to this idea of indiscriminately firing into a crowd. They are not permitted to do that. And then even when these weapons are authorized, there's an outright prohibition on law enforcement targeting head, neck, or vital organs of people, or using these weapons solely in response to curfew violations, verbal threats, or non-compliance with the directive from law enforcement. So that is a dispersal order. And these weapons can only lawfully be used with the frequency, intensity, and in a manner that is proportional to the threat and objectively reasonable.
Can you give examples of what those, of other protests where it was justified and where it's not justified?
Sure. So this is, again, most of the use of force cases that we contemplate have to do with how the force itself is used. So this goes back to like the proportionality question. Under the statute, they can't use them just because folks are not, honoring a dispersal order, but they could use them, say, if things were like getting violent or out of control and it felt like there was no other way to control this crowd. So again, none of this is satisfying. I realize it's hard to give concrete examples because a lot of this case law is also new. So it's things where the ACLU itself is like fighting actively in court. But in general, it really hinges on whether there's a violent public safety threat going on or whether it's just the idea is that less lethals cannot be used merely to control speech.
Not control speech, but control the crowd. So let's say, obviously, I don't know, depending, I guess, on I would say that somebody tossing a big rock can be violent, right?
Sure.
But tossing water can also be considered violent?
Again, I can't really speak on exact situations. That is something that's really contentious in a lot of these protest cases, whether throwing a bottle of water is considered a violent act.
Yeah, that's why I'm asking, just because I think it would be helpful for us to.
Right, yeah, honestly, there's not, it really depends on a lot of other factors that are involved.
Okay, thank you.
Yeah. Okay. So here in Santa Ana, the police department has a history of violating the standards under AB 48. In June 2025, there were various media reports covering Santa Ana Police Department's violation of the statute during protests after immigration raids erupted across Southern California. Police used rubber bullets, pepper balls, and tear gas. Media coverage detailed the ACLU SoCal's letter to Santa Ana Police Department detailing our concern over many reports from protests about violating the law. Again, whenever it comes to protesting, we advise that folks prioritize their safety and the safety of others. While all California law enforcement agencies, including police, sheriffs, and California Highway Patrol, are bound by this law, that does not guarantee that they will follow it. And if you witness officers using chemical projectiles, weapons in a crowd situation, or you come across it through social media, please document all that, including the types of weapons, the impacts on the folks who are attending, the agencies involved, the officers' names, badge numbers, and what, if any, warnings were given, so that we can evaluate whether or not it's in compliance with AB 48. These violations can be reported to the Attorney General, this commission, or you can inform your city council about violations of AB 48.
And just to jump in real quick, sorry, with a quick question. Did you say that SAPD has violated the law in regards to AB 48?
We believe so, yes. The ACLU does.
But just for clarity, there have been no documented legal findings.
Yes, based on our assessment of the situation, the Santa Ana Police Department did violate AB 48 during the raids last summer.
And do you have more specific details as to why you?
I can send along the letters after the presentation if you'd like. Okay, I will do that.
Could the commission receive a copy of those letters as well?
Absolutely.
Thank you.
So filming the police can be an important tool for accountability when it comes to unlawful uses of force and misconduct. What we advise for folks who believe that they're witnessing police abuse or brutality is to stand at a safe distance and, if possible, to use their phone to record what is happening in real time. And as long as you don't interfere with the interaction itself, what the officers are doing, and do not stand close enough to obstruct their movements, you have the right to observe and record events that are plainly visible in public spaces. Police officers may not confiscate or demand to view your photographs or videos, and without a warrant, they cannot do that, and they may not delete your photographs or videos under any circumstances. And if an officer orders you to stop recording or to hand over your phone, you can tell the officer that you do not consent to doing so, and remind the officer that taking photographs or videos is your right under the First Amendment. So the California Values Act is our sanctuary law in California. With the immigration raids both throughout Southern California and across the country that have occurred since last summer, we wanted to provide some information about what law enforcement's cooperation with federal immigration enforcement can and cannot look like, and provide folks with some information about what interacting with federal, what their rights are when interacting with federal law enforcement operations. The California Values Act ensures that no state and local resources are used to assist federal immigration enforcement, and that our schools, our hospitals, and our courthouses are safe spaces for everyone in our community. This means that state and local law enforcement agencies and school police and security departments cannot engage in immigration enforcement. In general, no state or local resources can be used to investigate, detain, detect, report, or arrest people for immigration enforcement purposes. However, there's a wide and complex range of exceptions for when law enforcement agencies can and do have discretion to notify or transfer individuals. Regardless of whether state or local local resources are implicated, state and local law enforcement are prohibited from detaining any person for deportation without a judicial warrant. Judicial warrants look different than administrative warrants, and if folks want to learn more about that, there's information on the ACLU's website where you can see them side by side to be able to determine whether what you're being shown is a judicial warrant or an administrative warrant. So what the effective SB 54 is that throughout California, police and sheriffs cannot ask about your immigration status. They cannot arrest you only for having a deportation order or for most other immigration violations. They cannot use immigration and custom enforcement's ICE or Border Patrol agents as interpreters. They cannot share your personal information like your home address with ICE or Border Patrol unless it's publicly available. They cannot hold you in jail for extra time just for immigration agents to pick you up. They cannot let immigration agents interview you without your written consent, and you have the right to refuse the interview and to remain silent. They also cannot tell immigration agents when you will be released or transfer you into their custody. There are some exceptions to that. However, Santa Ana's sanctuary ordinance is extremely strong. Here in Santa Ana, your city council passed an ordinance that takes an aggressive and protective stance for the immigrant community. It was passed during the first Trump administration and creates even stronger protections than SB 54. It also addresses some of the carve-outs that have allowed for cooperation between law enforcement and ICE in SB 54. So Santa Ana's local sanctuary ordinance places guardrails around the city's information sharing with the federal government about a person's citizenship or immigration status. It also prohibits local law enforcement from assisting or participating in joint operations or patrols that involve the enforcement of federal immigration laws. It also prohibits them from arresting, detaining, or continuing to detain a person based on an immigration detainer or federal administrative warrants based solely on violation of federal immigration laws. This also applies to interviews or transfers. And it prohibits them from enforcing any federal program requiring registration of individuals based on religious affiliation or ethnic or national origin. There are some basic rights that apply during an immigration enforcement, but there's a lot more information for folks who are undocumented, and there are many resources that we can point you to if that is something that folks are interested in learning more about. All persons, a lot of the rights when interacting with ICE mirror that when interacting with police, which is why we're bringing them forward here today. So all persons of the United States, no matter your immigration status, have constitutional protections. That means that in immigration enforcement action, many of the same rights apply: warrant requirement, consenting to search, right to remain silent, and right to refuse to sign documents without first consulting attorney all apply in immigration interactions. Immigration officers must have a warrant signed by a judge. Again, that looks different than an administrative warrant. Administrative warrants are signed by ICE officials, so they are fundamentally different from judicial warrants. For business owners, ICE can enter into public areas of businesses without permission, so that's lobbies, waiting rooms, anywhere that a member of the public could go freely. However, they cannot go into areas that are private, so that's employee-only areas without a warrant. DHS, as a note, DHS issued an internal memo claiming to be able to enter homes without a warrant, but that memo was explicitly excluded the Central District of California because of an ACLU lawsuit, Kid v. Nome, that challenged this. So DHS recognizes that they do not have the right to enter homes within our region without a warrant. If folks are outdoors and they think they see immigration officers nearby, you have the right to move to a safe place. We advise folks to avoid running if possible. It's a totally understandable and natural reaction to witnessing immigration raid. However, it can exacerbate the situation and put folks more at risk. If you are a United States citizen and feel safe to do so, you have the right to record that activity as well. We advise for folks to stay far enough away from immigration enforcement officers so that they would have to affirmatively walk towards you in order to make contact with you. If you are pulled over in a traffic stop and you're not sure if the officer pulling you over is ICE or a local police department, you can ask the officer where they're from, and you can explicitly ask them, are you ICE, are you CBP, which is Customs and Border Patrol? If they are immigration officers, if you're a United States citizen, or you have lawful immigration status, show them the documentation of that status. If you are undocumented, you have the right to remain silent, and you do not have to discuss your immigration status with them or any citizenship status with them. Anything you tell the officer, however, can later be used against you in immigration court, so we really emphasize the invoking your right to remain silent. But regardless, we advise folks to not provide any false information.
Excuse me, a quick question for you. It says show your documentation of status. What are those documents?
For citizenship?
Yes, ma'am. How would I show that I'm a citizen?
I mean, your driver's license is helpful, your passport if you happen to have it on you. Yeah, in general, it's your driver's license that we advise folks to present.
Driver's license is given to immigrants.
It is. It's a situation where if someone was coming to your home, it's the ideal would be your passport or your birth certificate, but folks don't regularly carry those on them, we recognize.
Correct. So, so you get stopped, show your documents. What do you? The driver license. I'm not carrying my passport around. I'm certainly not carrying my birth certificate around.
Sure, absolutely. Yeah, this is a real issue that folks are dealing with right now. That there's, we have seen United States citizens get detained. So ideally folks have some sort of verification of their citizenship, but right, it really is, it's a situation that we're in right now.
I mean, if you're brown, you definitely should.
I could be that. See, that's no offense, but that's kind of a racist statement on its own. I could be here illegally from Canada. I could be here illegally from any European country.
That is true, but
And you
people
don't
who
know
are
that I'm not.
racialized, people who are stopped are racialized. That was my point. Not they cannot.
The issue is that there's technically 500,000 undocumented
Well,
immigrants that are from Ireland, but they're not doing raids.
No, that's
in,
the issue is it says show your documentation of status. That was what I brought up, the question.
Commissioners, I'd please just caution and recommend that we stick within the scope of what's been agendized.
I agree.
Just a quick question. In the letters that you sent about the protests to the city, did the ACLU threaten to sue the city in those letters?
We did not take legal action, no.
Was there a threat to sue the city?
I don't believe so, but I think it was more of a call out of the behavior that we were seeing.
Okay.
I think we're a little outside, again, the scope of what's been agendized here with regard to know your rights, and we're getting into kind of specific fact-based circumstances that's outside that.
Yeah, we can provide those letters, but it was mostly, I think there were going to be protests that were going to continue, and so it was more of highlighting it for the police and saying that we believe there's violations, hopefully continue in future protests.
And I just wanted to jump in real quick and return to two prior points. We talked about Miranda for a little bit. I just wanted to provide my own perspective since this is a recorded meeting, public meeting. It's also my understanding that under the Miranda doctrine, those rights are triggered by custodial interrogation. So that's my understanding. Ali, as you say, agree to disagree. And then I just wanted to note again that I, as the Independent Oversight Director, have not found that SABD has violated AB 48 And again, there's been no legal findings from a court that that has occurred. So I understand that the ACLU has its own opinion, but that has not been verified by my office or a court.
Thank you all so much.
Thank you very much.
Thank you.
Thank you.
All righty. We'll have commissioner questions. We'll do 5 minutes each, and please, first 5 minutes, confine that to questions, and the second 5 minutes you can give your conclusions. Yes. And we'll start with Commissioner Gronsky.
I don't particularly have anything to say. This is a very nice printout. Thank you very much for that. Okay, but thank you for taking your time to come here and visit with us. We enjoyed it. All right, thank you.
Commissioner Vega.
Thank you for that presentation. It's very informative. This slide where it says, and it is never your responsibility to de-escalate an encounter. So I'm trying to figure out, so if I'm interacting with the police and I am really agitated, so am I interpreting it as it's on the police to calm me down? I don't have any responsibility to calm myself down?
And obviously, people should try to be as safe as possible.
Microphone.
Because that's how I interpret that. I feel like
Right.
you're telling people, no, you can continue to scream as much as you want. It's on the police to be nice to you. Like, I don't know.
Right. Well, I guess it's more of screaming is not illegal, right? And so if someone is just screaming, that doesn't give an officer the ability to, conduct an illegal search or seizure or whatever in that situation. If there's probable cause, then,
Yeah, I'm not talking about like what comes after that, but to me, escalation means altercation. That's what I mean.
Right. Yeah. Obviously, we urge the public to, try to be as calm as possible, and that's why, we want to urge folks to be mindful of their body and of their what they're saying and how they're acting in those situations to keep themselves safe.
Because I love the following slide, the strategies for reducing. I love that, but then I see the previous slide. I'm
Right.
like, just my opinion. But overall, great presentation. Thank you.
Vice Chair.
I have no questions. I just want to thank you for making the drive down from LA. I know it's a far drive. Thanks.
Commissioner Mejia.
Yeah, I just wanted to say thank you for the great presentation. I think the first two slides are exactly what the commission grapples with a lot, right? We have different perspectives, but I think that today was really informative. I do have one question. So like in terms of like knowing your rights, if I'm at a protest, right? It doesn't have to be here, just in general, and I'm following orders and I'm not doing anything violent, right? I'm just there with my poster, and an officer, maybe there's like one or two people that are not following orders, and there's no de-escalation and they just toss tear gas. My understanding is that then my rights have been violated, correct? According to AB 48, that would be the case. Okay, thank you.
They would be required to provide. Again, the use of force would have to be proportional to the threat. Obviously, that's not maybe proportional. Firing pepper spray or something in that.
Okay, thank you.
Commissioner Syed.
Thank you for the presentation. And like Commissioner Vega was saying, I really like the slide about reducing the risk to yourself. I think if we could do that more often, it would really make a difference, and you guys highlighted that, and I appreciate that, so thank you.
Commissioner Pereira.
Thank you so much for the presentation. I found it very comprehensive and robust, and I think that it definitely, we have had some recent reviews of policy related to some of the items that you're highlighting here. So this is also very refreshing to hear it from a different perspective, one that focuses on civil liberties. So I really appreciate that, and hope to see you both back here.
Thank you all so
But,
much. Oh,
no.
yeah.
I do have a couple questions.
Absolutely.
In the home and business, or home in particular, if your front door is open, that does not give consent, correct, for a search? Okay. And the second one, so 3 people in the house, one person says yes, one person says no. Does the search terminate at that point and they must leave?
Yes, anyone who's a resident.
Okay. And if they don't comply?
It's a violation of their constitutional rights.
Okay. All right, thank you. And again, thank you. That was a great presentation. I don't think we have any more questions or comments.
So,
Wait, sorry, one more.
Clarification on that one. So if you're an owner and you're renting out a room, you can't give consent to a police officer to search that renter's room, right? That's an application of that.
That's a wrinkle. It's the owner of the property. So if that person was to give consent to the police officer, then that is the person who has the authority to give it.
Oh, so he can give consent to search a renter. He's renting out a room to somebody. He can give consent to the officer to search that room that somebody else is renting from the owner?
Yes.
Oh, okay. Thank you.
One real quick question too. Minor at home, can they give consent or deny consent for a search?
Minors cannot give consent.
But they can deny consent, correct? Officer comes, they want to search the home. The
Oh,
minor
yes.
is home and they say no.
Yes.
Okay, thank you. All righty. I think that's it. Staff, have you captured the commission's direction? I don't think there's anything to capture on this one, is there?
It's a work study, just a presentation, and to get any questions that you needed answered. So for this portion, the work study is over. No action needed.
Thank you. All righty. Well, that's the end of the study session, so I'll move on to staff comments. Thank you, ladies, appreciate it.
Thank you all.
Thank you.
And I'll just note that our emails are in the PowerPoint that we could provide to the commission if it's helpful as well to reach us at any point for any further
Thank
questions.
you, appreciate that. Staff comments. Deputy City Attorney, do you have any closing comments?
I have just one comment. I know that there was a lot of conversation centering on Miranda, and there is obviously some debate back and forth. I always believe just going simply to the text of the case is probably the most helpful, and I'm not going to provide any commentary on it. I'm just going to simply read it and allow everybody to formulate their own opinions. It is important because this is going out to the public. I am reading Miranda versus Arizona. It is cited at 384 U.S. 436, and it is on page 444. Our holding will be spelled out with some specificity in the pages which follow, but briefly stated, it is this: the prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. As for procedural safeguards to be employed, unless other fully effective means are devised to inform accused persons of their right of silence and to ensure a continuous opportunity to exercise it, the following measures are required. Prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. The defendant may waive effectuation of these rights, provided the waiver is made voluntarily, knowingly, and intelligently. If, however, he indicates in any manner and at any stage of the process that he wishes to consult with an attorney before speaking, there can be no questioning. Likewise, if the individual is alone and indicates in any manner that he does not wish to be interrogated, the police may not question him. The mere fact that he may have answered some questions or volunteered some statements on his own does not deprive him of the right to refrain from answering any further questions until he has consulted with an attorney and thereafter consents to be questioned.
Thank you. City Manager.
Thank you, Chair. So wanted to let the commission know that on June 15th, that's this coming Monday at 6 p.m. at the Southwest Senior Center, we will be conducting our annual community meeting to talk about the use of the military equipment for that year. So you're all invited to come join us. Thank you.
Independent Oversight Director? Any comments, questions, concerns?
Not at this time, thank you.
Thank you. City Attorney, anything further, or is that good for you? Okay, thank you. Police Chief, Deputy Police Chief, I'm sorry.
Nothing. Have a great evening. Thank you.
All righty, now it's time for all of us to give our final comments. We'll start with Mr. Gronsky.
I'm freezing. I'm ready to go.
Thank you. Commissioner Vega.
Thank you, everyone, and happy Independence Day.
Thank you. Vice Chair.
I have no further comments.
Commissioner Mejia.
None.
Commissioner Syed.
Same, none, thank you.
Commissioner Pereira.
It's definitely freezing. Mexico won today, and happy World Cup to everyone.
All righty, yes, thank you again, ladies, for the presentation. Thank you all for showing up, all the staff, and 4th of July, birth of the nation. Let's have a good one and enjoy it. Thanks again. And, sorry, the next Police Oversight Commission is scheduled for Thursday, July 9th, 2026 in the council chamber at 5 p.m. I hereby adjourn the meeting at 7:57.